Hello, hello, hello. This is Attorney Mike Grevin coming to you from Chicago. As usual, we're back. We're back for verdict forms. Usually would not be worth watching, but after we witnessed the construction of Fort Brooks this morning, we got to see. So let's do this thing.
Yeah, without getting into further detail, there were drugs involved that people were giving to me that ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack, and
Well, here we are. Very exciting. Yeah, that's what we've got right now. Old DB sitting there. Really has appropriate initials. Where the hell are you, John? He's in the chat? I sent you a link, brother. I don't know where you are. Is he in the alternate courtroom? He's got his boxes. He's back, baby. DB has checked out. Of course, I did start early before I start giving John a hard time. All right, let me refresh my beverage here for a second. That would be good. A fort reconstruction in the main courtroom. That'd be quality. Thank you, Richard. Wait, shirt. Well, there's no jury to deal with, so he has a little more leeway, but I don't think it'll be long. There he is. Hey, Ben, how you doing?
Hey, I'm doing great. How's Mr. Brooks doing? That's the real question on everyone's mind.
We're all pulling for a reconstruction of the fort in the main courtroom here.
He's got his boxes, got the building materials.
All right. So now that we have times, when are we doing this this Vegas meetup we were discussing?
Oh, I don't know. With Blandino?
I mean, I come out there and visit you, but I don't know. Do they have any hotels or anything in that town?
We got a few. They're kind of. You might be able to find a
Is there
Hopefully
anything
it's
to do?
not too busy.
Anything you're gonna do when I get there?
Anything to do? Well, you know, depends on what you like to do, but I think you could probably. We got Wednesday night square dancing out here. We've got
That's what I'm looking for.
yes.
Oh,
So what do we just?
oh, the memes have been flying. I want to see all these.
Oh yeah, what do we got?
That was quite a performance. I mean, seriously, I've tried cases. I've seen a lot of jury instruction conferences. I've participated in a lot of jury instruction conferences. My first thought is this is YouTube death. We cannot watch a jury instruction
told you.
conference.
I got to give you an I told you so. I didn't.
You guys, I'm like, all right, I'm curious because every time I turn it off, he does something wacky. So I'm like, all right, I'll hang for a little bit, and then that was something.
That was, wasn't it? There is, yeah. I mean, it is. It's just crazy. Oh, was the judge coming in?
Here we go. It's on like Donkey Kong. Of course, he doesn't stand. Whatever. We don't care.
All right, we are back on the record. It is 1:01 p.m. State versus Brooks. Appearances are as they were before. I would note I have instructed, and Mr. Brooks is present in this courtroom. Prior to the, I understand your objections noted. If you would like to go back to the other courtroom, sir, you may, but that is a choice that you would be making. I am not requiring you. I'm not forcing you at this time.
So you're not holding me in contempt?
Sir, I am not requiring you or forcing you to go into the other courtroom. It is a new part of the day. I thought it appropriate to have you brought here.
Why?
And only if you forfeit your right by conduct will I put you back in the other room.
So you're going to address subject matter jurisdiction for the record, or are you going to state it on the record?
I'm declining to address that on the record for the
man.
reasons I've previously provided to you, not the least of which is I have addressed that by way of a written decision.
And it hasn't been proven for the record. You
Your
have to state
objection
it
is
on the
noted.
record. Can I go back in the other courtroom? Because I'm not going to do this with you. I'm not.
Mr. Brooks, I do want to.
Like he's the one who's disgusted.
Jury instructions.
With
I
this.
don't
Come
understand
on.
the jury instructions. I don't understand anything that's in these proceedings, and I'm not going to participate in something that I don't understand.
Yeah.
That's your choice, sir.
Maybe you should have
Now,
had
please
an
go back
attorney.
into the other courtroom.
You can, based upon your choice and your request, I'll make a finding that he's forfeiting his right to be present in this
I didn't forfeit
courtroom.
anything. I asked.
I understand you've
sorry,
asked, but
I
I
didn't
feel it's
forfeit
important to
anything.
also make a finding based upon your conduct.
Based upon what conduct? Me asking?
Are you willing to expressly
Oh,
waive
goodness.
that right on the record right now?
I'm not gonna expressively waive anything.
Are you willing to
I'm
engage in a colloquy regarding your right to be present
not-
and a
It's
a
knowing
variation
and
on-
intelligent and voluntary waiver of that right?
I am not going to consent to anything that I don't understand, and I will not answer any questions that I don't understand. I'm merely making a request to not be present in these proceedings.
And to be in the other courtroom?
Again, as I've stated numerous times now for the record, I will not
John.
answer or comply with anything I do not understand.
Well, that's going to be
gonna
difficult.
a
I'm not
real
making a
problem for
voluntary
you.
waivery of anything.
When did
Voluntary
that
waiver.
Are
start?
you willing to be? let me
No
rephrase
voluntary
that.
waiver. Oh, thank you.
If I have you stay in
Thank
this
God I've got
courtroom,
my
are you
fist
willing
handy.
to follow the rules of decorum and courtesy?
I do not understand the question you are asking.
Are you willing to
And you behave yourself like an adult.
not interrupt the proceedings with disruptive behavior?
I do not understand the questions that you are asking.
Well, given that he won't answer the questions directly, for now, he is to remain in this courtroom.
I'm requesting to not be in this courtroom.
But you won't answer my questions regarding that, sir.
I did. I told you I don't understand.
That's not answering the question, sir.
You asked me a question, I answered it. I don't understand. How can I answer something that I do not understand, Your Honor?
You've done that the entire
All right,
trial.
let me start
Yeah,
with.
why is that stopping you
jury
now?
instruction.
You
There
start
is
with
one I would
start
like
with subject
to.
matter jurisdiction.
No, I've declined that already, sir. I'm not
Oh.
gonna address
Under
that
what
further.
law? Under what lawful law?
I can't
Sir,
even take it off.
Do not interrupt me again
Back.
with the topic of subject matter jurisdiction, or you run the risk of forfeiting your right to be present in this courtroom.
Then let me go in the other courtroom then.
Are you willing to engage in a discussion about that, sir?
What am I
I
in
need
the
to make
courtroom,
an
Judge?
appropriate
I
record.
just told you that I
Doesn't
don't
want to,
understand
and
the
I
questions you're
understand
asking.
why.
What do you want me to do?
What don't you understand?
I can't answer something I
You'd
don't
be just as
understand.
disruptive in the other room.
I believe you're choosing not to answer them,
You can
sir.
believe what you want to believe. I believe that you hiding stuff from the jury. I believe you haven't been
Malingering is the
forfeit.
word.
You haven't let me even enter anything into evidence, which is my right to do so.
Yeah, it's malingering.
Your
But it
rights
doesn't
are
matter
not
what we
unfettered,
believe,
sir.
Your Honor. I'm merely stating a request to not be present for these proceedings. I cannot answer the
Sir,
questions you are asking me because I
seems to
don't
me
understand them.
You understand your right to be present in the courtroom.
Then maybe you shouldn't have fired your
telling me
I
lawyer
don't
out.
understand
that right?
anything. Nope. I don't understand. Nope.
Sorry, that was probably too.
Nope.
Then you're gonna stay here for now.
And under what lawful law?
Oh,
You
good
can't
Lord.
force me to stay somewhere that I'm making a request not to. You can't make me understand. You can't force me to understand what I don't understand.
You're absolutely right. Nobody
Can't force
can make
that.
you understand.
I need to address one of the jury instructions, number 315.
So, Your Honor, I'm trying to make a request to not be present in these matters without disrupting the courtroom, as you say that I do, and over talking you, as you state that
All
I
you have
do.
to do
I'm
is
making
shut the
a
hell up.
request merely to not be present for these proceedings. Obviously, I'm not needed because every decision that's been made here today has been made without my consent. That's clearly telling me that
That's how it
I'm
works.
not needed. I have never consented to anything that's going on here today.
I don't
I
know.
haven't even been allowed to present any evidence, which is something that I stated weeks ago. Weeks. You already knew, Your Honor, that I wanted things to present into evidence. I've asked numerous times for that and have been denied. And I don't understand why I'm not being able to adequately defend myself.
In your words, you're not being allowed to adequately defend yourself based upon your conduct in this courtroom
This
and
is what I
throughout
came
these
back to.
proceedings,
Oh God.
and your unwillingness to follow the simple rules of decorum, courtesy, procedure, rules of evidence. You refused to answer a variety of questions this morning when this court went through or attempted to go through the colloquy with you regarding your right to testify and your right not to testify. And because of that, and
I don't
based on the
think people
case
that he
law that I
murdered
cited this morning,
consented to
I
getting
made a
hit by a
finding that you
freaking
forfeited your
truck.
right to present further testimony
Yeah.
and evidence through other witnesses, and then you forfeited your right to testify on your behalf. I'm not going to revisit those, sir.
I'm not asking you to revisit them, but I'm just they weren't correct.
I understand you will
Because I
disagree with
never
that.
consented to it and I never answered something.
I understand
And
you
I
did
just
not.
stated the
Doesn't need to
reason why I didn't
consent.
answer
Come
because I
on.
don't understand. You cannot force me to understand what you're asking me.
Sir, I could not even get through the advisement. You wouldn't even listen. You talked over me repeatedly.
Was that from the other courtroom or in here? Because I've been over there all morning.
To the place that you are requesting to go back to, right?
You sent me into the other courtroom.
You're right, I did.
Right. So I've been over there all morning.
With an adequate audio and visual system connecting the two courtrooms.
Your
functional equivalent
to
of being
your
present in
equivalent
this
to
courtroom.
your equivalent is adequate, but to mine it's not.
We
Seeing
have the
as how
records in the
Nobody cares
mouth.
about
You
your
always state
standard,
Illinois
asshole.
versus Allen. You always state that. You always state that.
Murdered
But it
6
never
people.
it never refers to a fourth
Your
option
opinion
that you
matters
refer
to
to.
me
It never
nothing.
Brooks, I'm
refers
not
to
going to
it.
debate this with you. If you continue to bring up subject matter jurisdiction, Illinois
I didn't
versus
bring up
Allen,
subject
the
matter
decisions that I
jurisdiction.
made earlier,
I'm trying to figure out why I'm
then
being
you
held
are
in contempt.
frustrating purposes of this
I'm trying
hearing
to
right
figure out why
now,
I'm being held
which
in
is to
contempt.
finalize the
And
jury
then when
instruction and the verdict forms.
Your Honor, I'm merely trying to understand why when you hold me in contempt,
I never held you in contempt, sir.
you attempted to.
Nope.
You've never attempted to hold me in contempt.
No, sir. I'm not going to revisit all
No,
of these
she
issues.
is
When
not.
I asked you where you hold
Are
me in
you
contempt,
going
you
Wow.
said
to
civil.
respect the decisions that I've made
They're
by
not
not interrupting
they're
me?
not correct decisions, Your
I
Honor.
understand that.
I can't answer. You asked me questions. You asked me questions.
Maybe there's
I
no
didn't answer
lawful
them based on
law.
my understanding. How can you force me to understand what you're asking me if I don't? And then you still make
And
a
I think
finding
your
based
mic's
on that.
popping a little bit.
How is that lawful
I
law?
don't know.
Mr. Brooks, I stand
Everyone else is
behind the
hearing that.
record that I've
Or it's
made
just me.
today.
And that's fine. I'm not
And I'm advising you
arguing
that
with
if
you
you
about what you
continue
rude.
to talk
I'm saying
over
how
me,
can you do that without my
if
consent?
you continue to raise issues that I've
That's
already
a violation of
addressed,
my civil rights.
if you continue to raise these issues, sir, and thwart
All
the
right.
purpose of this court,
Even
which
more.
is to finalize the jury instruction and the verdict forms, you will forfeit your right to
Thank
be
you,
present
Jeremy
in the
DeWitt
courtroom,
Fez.
and you will appear from the other courtroom.
Okay.
Absent you, I know
And
you've requested to be there.
I made a request the moment we walked in here to not be present for these proceedings, but yet
But you
still
also won't have a dialogue with me about your understanding
because
of
it's
what that
my
means.
Fifth Amendment right. I'm exercising my rights that I reserved from the moment we walked in here this morning.
We could drag you in
can't
there.
you can't
Hannibal
force that.
Lecter style.
You can't force me. You can't force me to do anything. Actually,
Yes, they can.
No, you're
That's
right.
the
but I can
whole
make
idea
certain
here.
Findings that you forfeit rights
you
that
can't.
you have based upon your
And based on
conduct.
what lawful
You're
law
in
you're
custody,
I cited the
dummy.
law this morning. All right, I am moving
Illinois
on.
versus Allen, right?
I am moving
That I can be
on.
present from another courtroom
I surrender.
I need
if I
to
forfeit
discuss
my right.
Yeah,
instruction
bring him in
315,
freaking shackles.
Your Honor,
because
I don't-
believe
I
some
don't
language
understand.
needs to
I'll
be
be-
modified based upon the court's earlier.
This is just the
ruling.
I don't
verdict form,
understand.
right? Isn't this what we're
I
here
don't
for?
understand the procedures.
That's what we're here for.
Okay.
And I think that should be stated for the record. If I'm telling you repeatedly,
It has
Your Honor, that I
been. You
don't
said it.
understand. You can't force me to understand.
No, nobody can force
That's
you
a
to
violation
understand.
of my constitutional rights to try to force
Nope.
something upon me. That's coercion, Your Honor.
Coercion.
Mr.
Coercion.
Brooks, I completely disagree
Coercion.
with your characterization of the proceedings this morning.
Involve a
While it is
horse.
true that you did not provide consent, you were entirely
didn't.
uncooperative with court this
That's
morning.
because I didn't
and-
understand. I'm explaining why, Your Honor. I'm
And the
not
court
trying to
gave you
leave
You
it
don't
where it
have a
was at.
right to
I'm attempting
understand. You have a right
I'm
to have it
attempting to-
explained to you.
So I'm gonna
to
go.
explain myself of why I did not answer. It was because the way that you're making it seem is that I intentionally didn't want to answer, and that's
Mr.
not
Brooks,
fair.
I'm moving on to instruction 315.
And I still don't understand. So how can we even
I
proceed
don't care.
Mr. Brooks,
if I'm telling you I don't
understand
understand?
what that I'm asking you to be
No, I
quiet?
don't. No.
Stop asking me
I
to be as
don't.
understands.
Please stop
And for the
interrupting me.
record, I don't consent to being called that name, Your
You
Honor.
clearly hear me, sir, because if you didn't hear me, then you wouldn't make that statement. So I
Hearing
know
and
you can hear
understanding
me.
is two different
Oh,
things.
dear God.
Oh,
I know you
thank
can hear
you.
me, sir. I'm asking
Hearing and
you to
understanding
stop
is two different
interrupting me.
things. I'm not trying to interrupt
Oh.
you, but you're gonna
We're a
at some
therapy
point, you're
session
gonna
now.
ask me
Only are two different
my
things.
opinion of what's going on, and then when I tell you I don't understand, it's going to be taken as me trying to delay or trying
If
to do
you
this or
stop
trying to do
talking,
that,
I will explain why I'm bringing up instruction 315.
and I'm not going to understand your explanation.
Well, you can't say that if you haven't heard what I
Maybe
have
you
to
shouldn't
Didn't
have
you try to
fired
do
your
this
lawyer,
earlier before
asshole.
lunch?
But I need to clarify something because 315, which is the instruction that has it's titled Defendant Elects Not to Testify. I had it in there.
And so it begins.
However,
Oh God, it
that
took me
instruction
literally
should
15
really
minutes
only
for my
be given
brain
if
to melt.
requested by the defendant. There has been no request made.
This will take longer
And
than the verdict
obviously
forms.
This court made a finding
Yes,
that he
yes, it will.
forfeited his right to testify.
I was
And
shocked how quickly they
absent
were able to go through
Mr.
the jury
Brooks
instructions.
requesting that instruction to be in, I believe
The second they
it would
muted
not be
him.
proper for this court to include 315 in the instructions to the jury. Does the state have any position on that?
Your Honor, I did look at the notes that are associated with instruction 315, and I would agree.
Mr. Brooks, do you have any position on whether this court should include instruction 315 in the jury instructions to the jury?
I don't even understand what 315 jury instruction is.
It's
I don't-
entitled.
Then
Defendant
don't fire
Elects
your
on
lawyer,
I'll read it
stupid.
For you. It's my notes, meaning my materials, my jury instruction book says to be given only if requested by defendant, and it reads as follows. This is the actual language of the instruction. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. So my question is, do you want this instruction read or modified in any way?
No.
Put it in.
You just said I got a constitutional right not to testify or to testify. I didn't make either one of those decisions.
That's true, Happy. I do have real work to do.
Jury
But
instruction is typically read when a defendant does not testify. In every other case that I've had, the decision on whether to testify was a decision made by the defendant personally. In this case, the court found that you forfeited your right to testify based upon your conduct. That is the ruling I made this morning.
How did I make that decision though? I didn't.
My
I didn't
question to
never say
you
yes or no.
is,
I never
do
say
you
yes or no.
want the jury instructed that your silence must not be considered by them in any way and must not influence their verdict in any manner?
What do you mean my silence? My Fifth Amendment right?
Correct. I'm not hearing a request from you to have the jury
Because I
given
don't.
this
I
instruction.
don't understand why you're asking me the question, Your Honor. I never decided to or not to testify. I
I
never
understand
decided
that,
either
sir.
way.
I understand that.
So how can I answer that? I don't understand why. I don't understand.
We are now at the moment where we are discussing whether the jury should receive an instruction specifically on you not testifying, irrespective of the reason for that. I believe I could modify this instruction to simply say, a
I called it.
defendant's
This is going to be a
silence
difficult instruction
or a
from the
defendant
beginning.
not testifying should not be considered by the jury in any way and must not influence their verdict in any manner. Are you making such a request for a modified instruction?
I don't understand the question because I
Yeah, it
never
should be sponsored by
decided to
Marlboro.
or not to testify.
I
Never
understand.
said.
I understand what you're saying, sir. I
I never
really
said.
do. But in light of the court's decision that you forfeited your right to testify,
How did I
do
forfeit
you
something I
want
never
the
said?
jury to be instructed something to the effect of they cannot use your silence, meaning they cannot use you not testifying against you in any way?
I don't understand because I never made a decision not to or to testify.
I'll
I
ask
told you
one
this
more
was gonna
time,
be
and
an
if you
issue
do
this
not
morning,
answer with
like-
a yes or no, I will take your answer.
And I think Ben, you were
not
on too.
answering as
We
we're
knew
not
this was
making
gonna
a
be an
request for a
issue.
modified instruction.
How
Right.
can you do that?
Do
Your Honor?
you want this court, sir, to instruct the jury in any
because you were
way
hiding in your
regarding
box
you not
sports.
testifying in this
I
case?
don't understand the question.
All right, then based
I don't
upon there has
understand.
not been an express request made by Mr. Brooks to give either 315 as it's in the standard or pattern jury instruction or a modification as this court has suggested.
No.
315 is to be
No,
taken
not
out
this
of the
stage.
jury instructions.
How are all these decisions being made without me understanding?
Then I have looked over the verdict forms, and other than really what I would describe as some consistency in how phrases, whether there's all caps, not all caps, but
All caps.
what we call the sentence
Like the name that was
capitalization
on
for
there,
the
all
charges. For example, I want to be consistent with how I spell out first degree intentional homicide or first degree recklessly endangering safety. There was just sometimes it was capitalized, sometimes it wasn't. So we're looking through all of that to be consistent. Want to make sure the word information is capitalized since that's the charging document, things of that nature. It is my practice, and you should be aware, Mr. Brooks, that I always put the not guilty verdicts on top when I hand all the verdict forms to the jury. And by that, I mean it's by charge. So they're collated, if you will. So the not guilty followed by the guilty for counts 1 through 76.
You said it's collated. What do that mean?
So I put the.
I want
not
to be
guilty
clear.
and
The only
guilty
person
for
that gets to tell
count
me to
one,
shut up on
followed
his
by
channel
the
is Mike. So
not
all the
guilty and
people
the guilty for count
complaining
2 and so on and
that I'm
so
speaking,
forth, all the way
you
through
can go
the
pound sand.
remainder of the counts that are alleged in this case, which in this case total 76.
I don't understand. So how
I looked at the special questions
Will you
that
answer
are
that, Your
on the
Honor?
guilty verdicts only. They did appear to be proper. Again, just some grammatical things, but I believe those are all accurate.
Can I
I'll
go to
turn
the other courtroom?
state.
Since you don't have to answer any questions, but I have to answer all, can I just go to the other courtroom?
Yes.
Time.
Why not?
She's just saying no because he
I'm
wants
telling you, I
to.
don't understand these proceedings, and you just keep running right.
Thank
over
you,
my
Lynn.
notes like
Yes,
they-
I
like
did.
You don't even hear me saying anything.
Oh my
Attorney
goodness.
Basie, are you handling the verdict forms? Go
She
ahead.
said no.
Can I
She's
go
like,
to
I'm
the
just
other
gonna drag it
courtroom,
out.
please?
Send him to the state.
He asked to go to the other
I'm
room.
not waiving anything.
Then the answer is no.
I'm making a request.
Then the answer is no.
Then how's it?
Oh my goodness.
So what? You gonna try to force me to interrupt and do all this so you
I'm
can
not
make the
forcing you,
record
sir. I'd
and
like
make
you
it
to be
seem like
here.
I forfeited something that I came in here as soon as we got on the record and made a request to not be present for these proceedings. But when I'm making a request to avoid the drama and all that,
Sir, the only one with the drama is you.
it's you too. You the big contributor to the whole thing.
Mr. Brooks, I have to preside over this
What
case.
a
Yeah,
manipulative,
you haven't been impartial
gaslighting.
affair yet.
Oh my
Mr. Brooks,
gosh.
I have a question to the state. I ask that you not interrupt. And then I'll turn
It's
to
not
you
about
for a
me
response.
interrupting. It's about me attempting to understand. I've been saying that since we came in here.
Mr. Brooks, I
You
will
can't force
respond
me
as
to
follows to
understand.
that. You waived your right to counsel.
I didn't waive my right to no counsel. I
You
gave you the
waived your
contract.
right.
I did not.
It's on tape,
won't
you
sit here
moron.
and say that for the record because that is not
No,
what happened.
you are
No.
incorrect.
So we don't have the. Do we have the
When you're-
paperwork? Because I believe that I gave you the paperwork back that you.
Mr. Brooks, you
I gave it to you.
Oh, now you're going to bring up that you wanted
and
an
did not
attorney?
waive it.
have been presenting a nuanced argument regarding
That is
the
not
right
true,
to
Your Honor.
counsel
That is not
versus
true.
the right to
Have you
It's
been
an
here for the last
appellate
few days?
That's a pretty sophisticated argument. That's why
That's what it
I
looks
believe you fully understand what's
I
going
don't.
on in this
I
courtroom.
don't fully
I
understand.
disagree with your
I
characterization
disagree with your
of the
characteristics.
right to counsel.
You know that you accepted
You
the way that I
waived
gave it to
The
you.
entirety.
So you shouldn't have did that if you had questions of me not understanding.
I don't have any questions
You
whatsoever.
definitely
Least
do.
Kim
Because I'm
could
telling you
dance.
right now I don't understand, and you still won't even acknowledge the fact that I'm saying in open court on the record that I don't understand something. I haven't waived anything. You made decisions today that I didn't consent to, that I explained I did not answer because I didn't understand, which is my right to say that.
Right, Mr. Brooks, you
You
are
don't have a
right to
interfering with
understand.
the proper
To be
and
silent.
orderly
You have a right to
administration
counsel.
of these
Who does?
proceedings. I understand that you disagree with the decisions that I have made, but you aren't respectful of the decisions. You keep wanting to debate them and argue them. That is not the proper legal recourse at this time. I have asked you if you're willing to waive your right to be present. You indicated you're not.
Because
And
of
yet
the way
you continue
put it.
to
You said
interrupt.
waive. I'm not waiving anything.
Then that's why you're here until I make a finding that you, by your conduct,
No.
are forfeiting
He's
your
had
right to
4
be present.
Make the
competency
finding and
hearings,
kick me out. Make the
all of
finding
which
and hold me in
were
contempt,
inclusive.
which is what you waiting to do anyway. That's why
Yeah,
the courtroom
he's
is
just
set up the way it has. for the whole
malingering.
time.
He is. He's
At
just.
some point, it's anticipated that I will be
Ugh.
over there, which is not impartial and which is biased. It's judicial
Wait till we get to
misconduct.
closing arguments if we ever get there and he gets cut off for going down a.
I stated from the beginning
Forbidden
the
path.
goals of
Watch him go nuts then.
this
Hey,
trial.
Brian, if you don't want
Are you
commentary,
reading from the
go
paper, or are you
elsewhere.
reading, or are you just citing what you
Number
know?
one, sir, is during the evidentiary phase of this was to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process.
And I offered
That
evidence that you
includes
didn't allow.
developing relevant facts upon which a determination of guilt or innocence can be made. what is sometimes referred to in the case law as the ascertainment of truth. There's an equal but secondary purpose related to efficiency and effectiveness. That has been my repeated use of 906.11 is what that would fall under. There's a third goal of everything that I've done here, and that is the courtesy and decorum in this courtroom, what I've sometimes referred to as civility. Of course, there are other goals as well, including protecting your
Is my
rights,
mic crackling or is
protecting
it
the
Ben's?
record,
Because I know
protecting
Ben's
the
is on
jurors.
my
How's
on my
rights being
side.
protected, Your Honor, if I can't even put
What's
evidence
wrong?
into it?
With the
I can't
court
even admit evidence.
decisions.
I think Ben, your
sir,
mic's
Yeah,
crackling.
but how can
in
I?
a
How
Crackling?
can I defend myself if I can't
Yeah.
even present evidence?
But sir, you have not been willing to follow the rules of civility
But
and
that doesn't
decorum
have
and
anything to
trier.
do with my evidence.
It has
I could have
everything.
did that from the other courtroom too, correct?
Sir, you
If I
by
can be
your
present from the
conduct-
other courtroom, I should be able to present evidence from the other courtroom as well.
and you by your
The
conduct
evidentiary
this
phase is
morning, sir,
over,
are
idiot.
not willing to
I'm
answer
saying-
the
I'm
most
saying
basic of
Totality.
questions
The
about
totality.
whether
Your Honor. The
you
totality.
have
I
a
not
witness
asked to,
available.
have I not asked, in fairness, have I not asked to admit evidence? Have I not asked more than once?
Mr. Brooks, you have not asked to present any evidence.
Yes, I
in a
have.
legally
You told me we weren't at the
cognizable
evidentiary phase.
manner.
How would I know that if you didn't answer
And
answer the
you,
question?
as your own attorney, you proceed at your own peril sometimes.
That
Whether
has
you have a
nothing to do
full
with me
understanding of the
presenting
rules of
evidence.
procedure and rules of evidence or not. And
That
I
has
made that
nothing to do with me
abundantly
being able
clear.
to present evidence.
So, Mr. Brooks,
Nothing
This is your
nothing
final
I presented
warning.
have been able to be admitted into
I am
evidence.
turning to the state for a discussion of the verdict forms. If you interrupt me or them again, then I will make a finding that you forfeited your
Make
right
the
to be
finding.
present,
Make the finding.
and you will appear from the neighboring.
Seriously, make the
Once you
finding.
appear from the neighborhood courtroom, let's
I don't.
just let me go.
Attorney Basie, go ahead.
Just let me go.
I felt that all the verdict forms looked good. I did
I
ask
don't think
your
there's
clerk.
anything that actually
All
compels
right,
him to
he's
be there.
interrupted.
Why not just let
He's
him go?
forfeited his right to be here. He's chosen to do that despite the warning from the court. Will be
There
in
wasn't
recess
no
until
warning.
this
I'm the one
taken
that asked.
over.
So let's
To the other
make the record
courtroom,
correct.
and we
I'm
have
the one
the
that asked when
audio
we came in here, Your Honor.
And video working
I
appropriately.
asked when we came in here to
Madam
be
Clerk,
present
we'll
from the
have
other
to do it
court.
by Zoom because we may have to utilize the share screen in order.
We don't have to utilize no serious screen because I'm not going to participate in no proceedings that I don't
The
understand.
documents.
I told you I don't understand.
We're
a
in
million
recess until
times.
we get the courtroom set up.
No, we don't have to be in recess. I don't agree to it.
K-Far, send me a DM.
Say a word. Oh, and go ahead and put yourself on mute now.
No, it's not a defense. You do not have a right to actually understand what's going on. You have the right to be informed of what's going on, but you don't have a right to actually understand it if you're too freaking thick.
Which is exactly why you have a right to counsel.
Precisely. But if you
Right.
fire counsel and you don't know what the hell's going on, you know what?
This is what you
Then
get.
That's what you get.
I mean, this is why they have the phoretic canvas to go through this. He can't say that he didn't see this coming. You know, they warn him 6 ways from Sunday that you don't understand, and these are the bitter fruits you're gonna.
Oh, the whole thing's so frustrating. He thinks he's being cute, like he thinks I'm way smarter than this. I understand everything, but I'm going to pretend I don't understand and be a jerk. The fact of the matter is, he understands the basic commands or questions, but he really doesn't understand what's going on.
No, he has no idea.
He really doesn't get what's happening here in the grander scheme. But he knows he understands that. You know what? Whether or not he goes to the room and that kind of stuff.
He knows enough to be able to defend himself effectively,
Mm-hmm.
or at the very least, is capable of defending himself effectively. He is not doing it, but he's competent to stand trial. I don't have any doubt in my mind on that subject.
I agree. He's competent to
He went
stand
through,
trial.
I think, what was it, 4 competency hearings?
I think the fact that he's reduced to such stupid things, it shows that he appreciates that he's lost.
I think he recognizes that, and I think that he recognizes the general level of desperation that he's in right now.
Yeah, it's a wild thing.
Which actually does suggest competence. He doesn't want to sit there.
I'm looking forward to fort number 3. I really did. I wanted to see him busted out in the main courtroom. Oh.
I was half joking. I was thinking of coming back with a box fort on my desk. I didn't, but I was thinking about it.
Oh
Lord, it's childish nonsense.
I'm gonna clip that later and put it out where the moment we realized we were witnessing the construction of Fort Brooks.
Yeah.
From this morning, because that's him like, oh my God, this is happening.
Oh my Lord.
He's trying to create a basis for appeal. He knows he's got no shot, so then just act crazy and throw sand in the gears is all he's got. And he's doing that. But even that, like we said, even that shows rationality.
I don't know. I have to take a minute, so entertain the chat, and I will be back in a minute.
Am I still crackling? You.
Did you get yourself under control over there, Ben?
I don't know. I don't hear it, obviously, but oh well.
All right. I think I've created a monster.
All right.
What monster have you created?
Oh, the chat's talking about a nerd fest in Vegas. I don't know about that. I mean, my vision of this event was Ben and I, having lunch and then maybe Bible study after that. That's what I was thinking.
All right, dude. Sounds fine with me. And now we got a convention being planned.
I don't even know what to say to that.
Are they planning a law nerd convention?
Oh.
In Vegas.
All right. Where's our thing? How long are we doing this here?
I think that I think she was doing a 10 or 15 minute break, so we'll see. 10
or 15 minutes. So okay, so they started.
This is literally just for the freaking charging documents. It's literally just the verdict form,
right? But she started on it. She got through one piece of actual business.
Sort of.
You got to let him have his way. Go in the other room. Don't participate. Fine.
Okay, if you don't want to be in the courtroom, don't be in the courtroom. That's okay.
Here's where I part ways with her.
Go back to your cell.
Right. He asked to do that. Just do it. He's made a great record. I'm choosing. That's what I want. Okay. Have it. I don't see that creating any appealable issues. Of course, everything will be appealed because he's got nothing else to do with the rest of his life. So you can't avoid that. But can he win? And the answer is no.
No. At some point,
of course not.
He's going to file habeas petitions for the rest of his life.
We didn't get Fort O'Brien. That's not. Yeah, that's a bummer. I know.
Somebody said scream loud enough that Mike can hear me. That'd be a little tough. We're a few thousand miles away.
Yeah. Let me see here. Jen needs to draw the eyeballs on it. Can't you see that right now? That would be an appealable issue. That's the only one that might get somewhere in front of a judge. All right.
So Brooks is now appearing from the other courtroom.
She's back.
It appears he has headphones on. Speaking of headphones, I do need to make a correction to the record from this morning. I had made a statement that given his demeanor,
no.
the headphones had been taken off the table by the bailiffs. I was incorrect. Mr. Brooks handed the headphones to the bailiff, saying he didn't want to break them. All right, so we are discussing the verdict forms. Go ahead,
this
Attorney
whole thing
Basie.
is
you
your
can
fault,
complete your
Judge.
record.
Well, he's not guilty then.
For count 15, I have a not guilty verdict. I did not have a guilty verdict, but the way that it was on the paper made me believe that something happened, and I think you probably have it with your packet. It just didn't get printed off for me.
We'll make sure that that's there.
I want to apologize,
Any
Mike. Apparently,
misspellings of
some
any
folks in
names?
your chat think that I'm
That's
not
it.
a value add to this conversation.
All right. All right, I did, when we started up the video conference, Mr. Brooks has been muted. I am going to unmute him right now. And I should state again for the record, all of the verdict forms, or at least the drafts, were provided to him prior to the lunch break. So he would have had an opportunity to review them should he have chosen to do that. Do you have any position on the verdict form, sir?
I wasn't provided with anything, and if I was, I accepted and returned it for value. And since I'm now in another courtroom, are we going to address subject matter jurisdiction? We have yet to prove it for the record.
Mr. Brooks, you were provided with the verdict forms. What you did with them, I don't know.
Again, I haven't been provided with anything.
They were provided to you prior to lunch, the lunch
I
break.
haven't been provided with anything.
Teresa, you had the large packet of verdict forms. What were they? How were they given to Mr.
Make
Brooks
appointments,
prior
Christina.
to the lunch break?
All right, welcome to Law Talk with John.
To be
Are they even going to bother printing the not guilty on these verdict
that the
forms?
verdict forms were provided to him on his table.
Save the ink and toner.
I'm
I
up to
will
number 2.
remind
people.
you once again that I do,
Just pouring it
it's my
home.
practice to put all of the not guilty verdicts on top of the guilty verdicts in a collated fashion. Again, I saw a couple of just cleaning up, I would say, not with the words themselves, but just capitalization of various words within the verdict forms, and I'll make sure that's done.
Thank
The
you.
appropriate counts had and have the appropriate special verdict questions. Those special verdict questions are only as they relate to guilty verdicts related to the use of a dangerous weapon for counts 1 through 6, the homicide counts, and then 61 through I believe 60.
It would be 7 through
7 through 67 have that
Pound
special
ginger
verdict,
zero.
and then the hit and run counts have the special question related to did each of the counts involve the death of a person, and it names the person alleged to have been killed. So those look to be all in order. I've already addressed going back to the jury instructions 315. We have done a little bit of rearranging some of the order, but the content is there. It is my practice to
Hey, there's one man on earth that can tell me to
read
shut up.
through all of the instructions up until the point of closing arguments. And then I stop. Parties are given their opportunity to argue the case to the jury. And then following that, there are what I like to call the closing
I'm thinking
instructions,
about it.
which are still quite lengthy in this case, given that they go through the verdict forms specifically. And then, of course, the alternate jurors would be selected. But given,
Am I muted?
no, you're not, you haven't been.
So I got a question about
Yeah, but they smoke too long.
the hazard for use of a dangerous weapon. How's that being charged? Is that under
Thank you, Cal.
939.632?
It is in the charging document, sir.
How's that being charged from my understanding that the statute
Mike
is
did
increased penalties
tell
for
me
violence
to
and
try
does
and
not apply.
cut down on the
If
cursing.
possessing,
So I
using, or
have been
threatening to use a
trying.
dangerous
It's just
weapon is an
difficult with this
essential
guy.
element of the crime charge. Without the vehicle, there is no crime. So that would apply. So how am I charged with?
State want to
Rather-
is your argument only as it relates to counts 1 through 6 or others?
Whichever count has the enhancement penalty for use of a dangerous weapon.
Well, that would be all of the intentional homicide charges and all of the first degree of recklessly endangering safety charges. So counts 1 through 67.
So 1 through 67.
Correct.
Everybody go over
I can
there.
have the state respond to that.
Yeah, how
Jay Robine.
how is the alleged defendant being charged?
So are you asking how are you making a specific request as it relates to the special verdict question?
I would say both.
Yes, I was
Yeah, now
looking
he
for it
understands.
disrespectful.
Seeing as how I don't understand how,
Oh, my bad.
that's why there's the question. Reading the statute,
And
How
which
is
part of
that?
this? I'm sorry. Which part of the statute are you referring to again?
I don't
I
care
believe
if it's
it's
female or male
9.9.632.
judge. He's being very disrespectful to the court.
And your specific argument is what again?
how is that enhancement, how is the alleged defendant charged with that enhancement when reading the statute, it says it, well, I just read it, so.
I believe you're referring to sub 2, which states the increased penalty provided in this section does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge.
Right, that's what I just read.
Is he trying to argue that his car is not a
What's the
dangerous
state's
weapon?
response?
Using, possessing, or threatening to use a dangerous weapon is not an essential element of either first-degree intentional homicide or first-degree recklessly endangering safety. If it were, it would be one of the
I just like the
elements
irony of
in
this.
jury instructions, and the defendant can see it is not. This is different from a
Yeah, it's just
situation like
error.
armed
That's the
robbery,
only thing that I would be
where
treating.
used or threatened use of a dangerous
Oh,
weapon.
the
So,
irony.
the penalty enhancer is correctly charged for those two types of crimes.
Any final argument on that, sir?
Yes, that's not what the statute is clearly saying. It's clearly stated it does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge. If there's no vehicle involved, where is the crime? It has to be an essential part of it to even be a crime. The alleged defendant is charged with using a vehicle to commit these crimes. If there's no vehicle, where's the crime?
Yeah, cool story, bro.
So it has to be an essential element of the crime.
Just so
Otherwise,
people know,
there's no
I'm
crime.
6'4" and change. So
I think it's the essential
There
element.
Where's the? I mean, they have pictures of the jury viewed the vehicle physically.
You can't just walk up to
he
someone.
did.
You can't just walk
They
up
did
to
a full
someone,
field trip.
quote unquote,
Answer your question.
run them over. There has to
Where's
be
the
something
vehicle?
used
We saw it.
in order for this alleged crime to transpire, and that would essentially mean the quote unquote dangerous weapon. So without the
No, a vehicle is absolutely a dangerous weapon. That's not
quote unquote
quote-unquote
dangerous weapon,
Anything
Where's
in
the
the way
crime?
in which it's used could
so
cause
how
death or
can it be
substantial bodily
charged when
harm.
it is
It's considered a
the
deadly weapon.
essential element of the crime charge?
I've had cases where rocks were deadly
sir, I've
weapons,
listened to your
cars, you name
argument.
it.
I've read the statute. I've looked at the elements for intentional homicide and first degree recklessly endangering safety. Neither one of those crimes have as an element in it use of a vehicle. There are certainly many different ways that both of those statutes can be violated. While it's true that in this particular case, the use of the vehicle is the mechanism or instrumentality that's being alleged to have been used, but it's not the same as being an essential element of the crime. I think the armed robbery crime is a good example of when you could not face an enhancer for use of a dangerous weapon because you can't have the crime of armed robbery without the threat or use of a dangerous weapon.
Oh, good Lord.
And
That's
so,
the same argument.
No,
you get,
stop
Your Honor.
tolerating
You can't have this alleged crime without the use of the vehicle. It's the same. It's the same thing.
it's not an essential element of either first degree intentional homicide or first degree recklessly endangering safety. So I'll deny the request to strike the enhancer for those reasons and find that it is properly before the jury for their determination.
Okay.
I respectfully object to that, Your Honor.
Understood. Do you have any other challenges to the verdicts you'd like to raise at this time?
Yeah, would that be, will my objection to that be noted for the record?
It is.
No shit,
Now request a
Sherlock.
legal reconsideration of your ruling, Your Honor?
Denied.
May I
Sorry,
request
I'm trying to do better,
finding
but
of
I
fact
just-
for your ruling, Your Honor?
They
Denied.
can't.
Just for the record, it's my understanding that the verdict forms were put in the garbage by Mr. Brooks and they remain in there. That was provided to me by the bailiffs.
May
That
I
information.
respectfully request a written judicial finding of facts and conclusion of law for this issue, Your Honor?
You may request it. The request is denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
This is not the proper court to grant such relief.
Interlocutory,
For the
declaratory.
record, may I move to stay these proceedings until this instant matter is adjudicated by a court of
It's almost like he doesn't know what he's talking about.
Your request is denied.
No, he has no
Based
idea
on
what
what
those
law
words
or fact?
actually mean.
Your request is not based in law or fact, sir.
I just read a statute that it came from. My argument was based on a statute, a Wisconsin statute.
What?
Your request is noted. Your objection to the court's finding and determination is noted. I decline to issue any type of written decision or stay pending appeal, noting there is no appeal that has been filed.
May I let the record show that this court will not allow the accused to adequately defend themselves in this matter?
No, she
Court's already
made
made
a
its
massive
findings
record.
regarding the forfeiture of right to testify and the forfeiture of the right to present additional evidence and testimony.
Which was not,
I'm not going to
which was not
revisit the
consented-
same.
Which was not consented to. I never stated that I did or
She
did
made a
not.
massive
Understand.
record, and 6,000 people
So how
on
can
Wall
that
Talk with
decision
Mike
be made
saw it.
on my behalf when I didn't say either way? What I stated was I didn't understand the questions being answered.
So do you have any other
And
questions
you don't
or
have a right to
issues regarding
understand.
the
That's
verdict
why you
forms?
hire a
Your
lawyer.
Honor, are you making a judicial determination that you don't have to answer any questions?
I'm not answering those questions, sir, other than
Or
how
is
I've
that-
already answered them.
Is that a judicial determination?
Sir, every decision I make is a determination by this court.
Is it a judicial determination?
Sir, I will ask you once more, do you have any other issues
And I will
to
tell
raise
you once more, I
with-
don't understand the questions that you are asking.
Sir, do
So
you
I
have
would-
any other issues to raise with respect to the verdict forms?
I do not understand the questions that you are asking.
That's
I-
okay.
No,
You don't
I
have to
Not
understand.
answered the question. I'll ask one last time and specifically advise him that his failure to answer the question will be taken by this court as a no. Sir, do you have any
what law of
additional,
fact- Under what law of fact can you say no? When I'm
sir, do
telling
you
I
have
don't
any
understand.
additional issues to raise with respect to the verdict forms?
I do not understand the questions that you are asking.
All right, he
I
has
don't
chosen
understand.
not to answer other than by saying he does not understand the questions. He did not specifically answer with a yes or no. Therefore, this court takes that as he does not have any additional issues to raise with respect
That is incorrect.
to the verdict forms.
That is incorrect. I stated I don't understand. You can't
Yeah,
force
we've
me
heard.
to understand something, Your Honor.
You
Right.
said that.
Did
We
the
get
state
that.
have any
It
other?
is
I
my
want to mute him
constitutional right.
momentarily.
It's
Mr.
my
Brooks, I'm muting you
constitutional
because
right.
I'm moving on to another topic. I understand you disagree with the court's rulings, but you need to respect the rulings with proper etiquette in this courtroom, which you are demonstrating once again you're not willing to follow. So I exercised my ability to press mute. Does the state have any other requests as it relates to the jury instructions? I want to kind of full circle back to that because I do need to approve of them.
Yes, we do not.
All right, Mr. Brooks, I'll ask you the same question. I will unmute. Do you have any
Oh,
additional
please don't.
requests
No,
as it
God.
relates to the jury instructions?
Yeah,
Please
I
don't.
have questions related to all of them because I don't understand any of this.
My question was not, do you have questions?
Of course
Do
you
you
don't.
have any
You're not a
requests?
lawyer.
And my
Of course
answer
he
was
doesn't.
I don't understand.
Freaking moron.
And I've made several requests.
The requests are not related to the jury instructions, which is the phase of this hearing that this court is attempting to conduct with you and give you the opportunity to fully participate. Mr. Brooks is choosing not to answer my questions.
You did not.
I'm going to mute him momentarily, sir. I will ask you one more time if you have any requests as it relates to the jury instructions. I then will ask you if you approve of the jury instructions. If you do not answer those questions as it relates to the question, do you have any requests as it relates to jury instructions? I will interpret that as a no. And if you do not
He's
specifically
full of
answer the
garbage.
question about the jury instructions, I will interpret that as your approval. So first question to you is, do you have any, and you're unmuted, do you have any requests at this point as it relates to the jury instructions?
And I just said before, I said I do. I said I don't understand the questions. Of course I have questions if I don't understand.
So do you have any
That's common
requests
sense.
for any
If you-
additional instructions that
What?
are not included, or to remove any that are
What?
included?
Yeah, remove them all until I understand, or add the jury instructions that I have myself.
What jury instructions do you have, sir?
So now,
What?
so now you don't know I had jury instructions, and I told you this weeks ago.
What filing are you referring to, sir? If I've overlooked that, I will certainly reconsider, but I'm not
You
aware of a
overlook them.
specific jury instruction.
It seems like you overlook a lot, Your Honor.
Can you
Okay.
point me to a specific filing?
So you have all my filings on file?
Do I have all of your filings on file? For the love of
Are you
God.
saying that you have my filings and they haven't been admitted into evidence?
Oh, sweet
No.
Jesus.
A filing doesn't
Oh, no.
put it in evidence. Oh, God.
Sir, please direct me to the specific filing that you're referring to that has a request related to jury instructions.
You just said you was referring to the filings, right? Did you just say that?
That's not what I said.
Didn't you just say what filings are referring to jury instructions? Did you or did you not just say that?
I said, do you have a specific
All right,
filing
folks.
you can
I need
refer
a
the
minute.
court
I'll be
to
back.
that relates to jury instructions?
So is your computer working or is it not working?
It's being a little
I said this
temperamental,
week ago.
but I just can't use my search function. So if you can direct me to a filing, that would be great.
It would also be great for those filings to be admitted into evidence.
Sir, simply filing something with the court does not make it evidence during the evidentiary phase of a trial. There are rules of procedure and rules of evidence that govern that.
And you told me to make all my filings in writing.
Sir, I said if you had a motion, it needed to be put in
All those
writing.
were motions. All those were motions.
Sir, what filing are you referring the court to?
Look through all my motions.
Sir, it's not my job to advocate on your behalf. If you have something in
I didn't ask you to advocate
particular,
on my behalf.
Sir,
I asked you to do your job.
Sir, if you have something, a specific request, now is the time to make it.
Well, how about this? I don't accept none of those jury instructions. I don't accept any of them. Hey, why do I have to keep?
I don't accept any of them. Okay.
When it's clear that I don't understand.
Your Honor, I can inform the
Oh,
court
my
that,
Lord.
Jury instructions were due, I believe, on August 30th. The state submitted their proposed jury instructions as well as the substantive instructions, and the defense indicated that they
disagree.
agreed with our filing.
He would do this to
So
a
I
male
don't believe
judge.
that there's ever been a request for any different jury instructions than what have been filed with the court.
So what jury instructions are you referring to, or what document is being referred to on the alleged defendant's behalf? Because as we all know, I didn't obtain the discovery in full until the end of September. So there was documents that I didn't even know that existed.
Mr. Brooks, one final time, do you have any specific requests as it relates to the jury instructions other than your request that they all be struck?
And I'm telling you, Your Honor, I don't understand the question. I can't.
All right, then I will take his response that he does not understand, that he does not have any additional requests.
I didn't say
And
that.
they will be
I said I don't
approved.
understand.
They will be
You
approved
can't-
and are,
No.
I'm gonna have to mute
No.
him. They are approved as been drafted by the court and modified during the jury instruction conference on the record this morning and this afternoon. I will once again review all of them just for grammar,
Sorry,
just to
folks,
make
I
sure
need a
all of
minute.
that is correct. And provide a written printout of the final draft for the parties before we break for the day today. I am also approving of the verdict forms that have been previously submitted to the parties, just noting there's just a few grammatical things that
At
need
this
to be
stage of the game,
corrected.
I don't think a lawyer would even help.
Content and substance are there, and I've already addressed on the record
No, I don't
requests
feel
by
better.
the parties this afternoon.
No, Your Honor.
That's
I believe that the
culturally
final
inappropriate.
copy that we've been working off of is appropriate.
Any comment about that, Mr. Brooks, or any statement?
No, don't ask him. Stop asking him
You know that
questions.
name, and I just told you I don't understand these jury questions. I'm not going to know how they allowed to pass just because you feel that they should. When I'm telling you I don't understand it.
I would note
None
that
of
his,
those, not one of those jury instructions came from me. Not one. How's that fair?
They handed them to you this morning,
Brooks,
and you
this
threw them
court
in the trash
gave
bag.
you the draft
didn't
of
give
the
me
jury
anything.
instructions.
You didn't
I
give me
need to
anything.
mute you because once again, he's debating about things that I think are very clear on the record. This court provided both the state and Mr. Brooks with a written printout, 107 pages long, of the jury instructions it was considering in this case.
Okay, I feel
We
better
had
now.
a discussion this morning. We continued that discussion this afternoon. Prior to breaking for the lunch hour, all of the verdict forms were printed off and provided to both the state and to Mr. Brooks. It is also true that when he was previously represented by counsel, the court had some specific deadlines related to jury instruction proposals.
Nowhere.
And the state reminded me that there
Answer is
essentially
nowhere.
was not an objection raised regarding the proposal and the filing from the state. I had a brief opportunity to look through the record of the inmate communication forms that have been sent during this trial that are on file. I haven't seen anything that references jury instructions. I'm well aware that he has other filings, but I could not find anything related to jury instructions and any specific requests that he is making or made during this case. So for the record, I am approving of the verdicts. I am approving of the jury instructions. And once again, before we break for the day,
No.
I will make sure to
You
provide
think?
the parties with written printouts of both of the documents as they now stand. Then there are a few other issues we need to go through. Attorney Basie, I think you brought these up prior to the break. Maybe it was Attorney Opper in terms of scheduling and what I would
we are
consider
there.
other housekeeping
They're
issues,
closing
but
this
go
out
ahead
till
and
tomorrow.
remind me
Tomorrow
again
should
of the
be.
issues you wanted to bring up.
Well, I mean, they already
I think
released
it was
the
the
jury,
alternate
so we knew nothing
sequestration
was going to
and
happen
there might have been a third.
substantively until tomorrow.
Yes, Your Honor. The question is to the sequestration of the jurors once they are excused for deliberations, and should the timing require that, an overnight stay or something along those lines. We wanted to discuss that. We wanted to
It'll take
discuss
30 minutes.
what the court intended to do with the 3 alternates once they have been selected.
It takes
It will be our
literally
request, the
12
position
people
that
to
they
sign
should
their name to a
remain in
piece of
secure
paper.
location, separate and apart from anyone else, unless and until full deliberations are complete by the 12.
Why bother with
selected to
sequestration at this
decide the
point?
case.
If you have a
So
phone,
that
it's
if
over.
needed, and in light of the brief COVID history we have on this record, if needed, one of the alternates could slide into position of one of the 12 who are
Oh,
deliberating.
dear God.
If that became
This
necessary.
deliberation will not take
So we
long.
wanted to address
No.
that, and then we just wanted
Granted,
to address
it's, what is it?
timing
68
generally
counts,
for
whatever the hell it is.
closing arguments,
They're going to sign all of them
verdict,
instantly. I
returned by
doubt
the
there's going to be
jury,
any
and
debate.
then the court's intentions as to the rest of the week, should there be guilty verdicts returned.
Sure. Before I address all of those,
That's
are there
in
any
the
of those
sentence.
final type
Thanks,
of
Sam.
issues,
Yeah,
sir,
it's
that
not
you would
relevant
want the
here.
court to address? You have been unmuted, so you can answer that. Mr. Brooks, do you have any of those final type of questions or issues that you want the court to address? You are unmuted. I am.
I just told you since nothing I say even matters at this point, I'm just gonna tell the jury what they need.
You're
to know.
right.
I'm
Nothing
gonna
you
tell
say
them.
matters at this point.
Mr. Brooks, you are aware that your closing arguments have to be based on law and fact, correct?
They're gonna be based on whatever I'll base them on.
Oh, dear God. Tomorrow.
Oh, here we go.
I trust the
Oh, there's a
state
nice
will
foreshadowing of this
when
event.
appropriate,
Well,
if
It's gonna be
appropriate.
a whole lot of objection then, because I'm gonna tell the truth. You haven't allowed. You just been making all the decisions for me, even though I told you repeatedly that I don't understand, and you still make decisions based on.
Maybe you should have had a
on my behalf
lawyer,
without my
dipshit.
consent, without me. I'm
Sorry.
telling you I don't understand, and you still make a decision determining my life.
Are you telling me, sir, that you will refuse to follow the simple rules of decorum, courtesy,
It ain't
civility,
no-
the rules of
don't
evidence,
try to
and
come- don't try to
You're
come with
going to
some slick words.
forfeit your right to a
Don't try to
closing
come with
argument.
some slick words, and don't put words in my mouth.
sir, I am not being slick. I'm trying to
You've
preserve the integrity.
been slick. You've
All right.
been slick.
All right. I'm going to mute you, sir, since what you are saying is not productive. It is not courteous. It is disrespectful.
I don't care.
I
what
need
you
to
think.
I need to go
I don't
over
care
these.
what you think.
All right, I'm muting
You
him
know what, Mike?
because
If
I
you
need
can,
to go
put
over
up a
these
poll.
important issues
What are the
that have
odds
been
that he
raised by
forfeits
the
his right
state.
to a
So as
closing
far
argument?
as the alternates, I do think it is
I'd just be
important
curious to say
to
that.
keep the alternates who in a secure location, even if that means an overnight, unless and until verdicts are reached in this matter. And I will so instruct the clerk of courts to make those arrangements. We have been doing that all along in any event. As far as selecting the alternates, obviously each of our jurors have a number. I intend to have pieces of equal size pieces of paper made, folded up with each of their numbers, put them in the same turnstile bin that we utilized for the selection of jury preemptory strikes by lot, and to simply pull out 3 names. Those will be the alternates, and then or I should say not names, the numbers, and then the numbers that are remaining would be those 12 who will deliberate. And so I'll make sure that that's out here for the appropriate time. As I indicated this morning, all of the jurors were provided with some information regarding sequestration. It is the practice of that I've approved in this case that the jurors provide us with certain emergency contact information so that we are able to get a hold of families should there be the need. They're given information regarding sequestration, the purpose of it. If I have not made that a part of the record, I will make sure to get a copy of that filed in this case so that both sides know what was provided to the jurors today before they left. And then I'll also make sure that when the 12 are deliberating, that the 3 who are not are taken to a different jury room with a bailiff, and again, kept in a secure location, but separate from the other 12. In the event one would be needed, we would then take up that issue at that time, but I think it's good practice to have them available if that becomes an issue. As far as timing, I'll first address, I have instructed the jurors to be back at 9 a.m. That's because typically we have a few things to finalize in the morning, so we'll start at 8:30 tomorrow morning.
8:30 as usual.
It will also give the parties one final opportunity to read through the many, many pages of jury instructions and verdict forms to just make sure there aren't any other issues that jump off the page or that need to be addressed first thing tomorrow morning. And then I do intend to start with instructing the jury. This case will require a very lengthy time of the court reading off the jury instructions. I do believe it will require me to take some regular breaks, probably every 2 hours, until the jury instructions are read, with perhaps a longer break at the lunch hour. And my best guess is that it'll take between 5 and 6 hours to fully instruct the jury. That's based on the 107 pages. Now, some of those pages, though, are after argument. And so that really kind of begs the question is, will the parties get to their closing arguments tomorrow, or will that be done Wednesday?
If they don't, I swear to God, Judge.
I certainly would like to have the parties make their arguments. Madam Clerk, may I see the instructions that we have thus far? The packet?
I don't think Mike or I want to go into Wednesday.
Single side.
It's 107 pages.
So the instructions that I read prior to the parties giving their closing arguments finishes on page 73.
Oh, good Lord.
So given that, I believe that the parties will be able to give their closing arguments tomorrow. It just may be, depending on where that takes us,
it might not be a bad idea to skip the morning.
Are given the following morning, because that's another 30 pages. I'd like to be able to do it.
Okay, so we're doing
It just
openings
really
tomorrow.
depends on how late of an evening.
No,
I'm
you
not
already did
opposed to
opening.
going
The
late,
question is, there are 73 pages
letting the jurors
of
go to the
jury
hotel and
instructions
then
in
starting
the
their
morning.
deliberations in the morning if that's what needs to be done.
Understood, and we'll be ready. I think from our
They
recollection,
are
it took
sequestering
them
the jury.
about 2.5 hours to read.
He's already talking about putting them in the
preliminary
hotel,
instructions,
including the alternate.
69 pages
That's
in length.
interesting.
So if that holds, I think, we reasonably could do closings in the afternoon, and it'd probably take you about an hour, hour and a half to read those remaining 30 pages. And we may still be able to wrap up by 4 or 5 o'clock in the courtroom.
I think that's a reasonable time frame. Do you have any estimation on the length of your
Oh
closing?
God, don't
I'm
make me sit through
contemplating
her reading the jury
maybe putting a
instructions.
time restriction for both parties. I mean, we had a solid 15 days of testimony, so I'm mindful that this is not a 30-minute closing.
Well, actually, I'm trying to keep it in the 30 to 45-minute range, just out of courtesy to the jury, and to highlight the important points.
Damn, she's going to try to keep it short,
reasonable
which I
to
think
give
is
the
good.
parties each an hour total. That
Good
would
for her.
reserve whatever's left from your
Confidence.
initial for your any rebuttal.
Yes.
All right, Mr. Brooks, do you have any position?
She knows
on that?
exactly how
you.
long her
I would note he takes the
closing will
headphones
take
on and off throughout.
because
He
she's
doesn't have them
practiced it a
on.
dozen
He's
times now.
looking at a book.
That's impressive.
I wish you would stop saying, look, I'm looking at the Bible. Thank you. It's not just a book, it's the book.
Can't disagree with you there, sir.
Yeah. I mean, people actually live by it, though. Anyway.
Sir, I'm contemplating putting an hour time limit on closing arguments.
I ain't doing no closing argument tomorrow.
The closing arguments will most likely be tomorrow.
I'm not doing it tomorrow.
Then
You don't get a
forfeit your right
choice.
to give one, sir, because as we have.
You can't force me. You can't force.
Is he gonna forfeit it tonight?
What type of court is this where you can say you're gonna force somebody not to be able to give a closing argument? How's that lawful law?
If you choose not to give one,
how's that lawful law?
sir, if you choose not to give one you're not letting me finish and you're mocking me right now, which is
You could say,
incredibly
Your Honor, I
disrespectful
don't have
once
enough
again.
time.
You didn't even let me get my
Can
sentence
I
out.
let it bleed into Wednesday?
Incorrect record. Go
And
ahead.
she'd probably say okay.
I'll mute him once again because clearly he just wants to be disruptive this
She'd
afternoon.
probably say
But
okay
as
on
we
that.
have been talking about over the course of the last,
I'm not
10,
sure I can
15
finish it in
minutes,
45
talking
minutes
about
or
the
whatever the
timing
hell
of
it
everything
was.
tomorrow, even though I have 107 pages of jury instructions. The first 73,
Yes.
I think, deal with what is read prior to closing arguments. That means the parties should be prepared to give their closing arguments tomorrow afternoon. I will do my very best with just one mid-morning break to get through all of these, the first part of the instructions. Then the state will give its closing argument. I'm giving the parties 1 hour each. I think that's reasonable under the circumstances.
That is.
Whatever the state doesn't use in its initial time of closing arguments, it can reserve for rebuttal. But then following the state, we may need to take a break of some sorts, probably before the defendant goes, just for the jury's sake and the party's sake. We will need a comfort break. But you should be prepared to go tomorrow afternoon. Then the state, if they have any rebuttal, will get up within that time limit. I will myself, and I'll have my clerk make sure we accurately time that. I will read the final instructions, and I'll really leave it in the jury's hands. If they want to start deliberating,
Given the number
that's
of charges, I might have requested a little
if
extra
it's 7
time.
o'clock at night, I'll probably tell
And
them
whether that's going into
we're
the
gonna
evening
break for
or
the
to the
night.
next
They'll be
day, I
sequestered,
don't
but
care
they
which.
will come back and begin deliberations in the morning. That will be Wednesday morning. But now that I really kind of laid that out and thought about the break I will have for closing arguments
agree,
with more
Mike?
than my 107 pages, we can get this done tomorrow. And so that's my expectation. So, Mr. Brooks, I'll unmute you, but that is the expectation of the court, that closing arguments
No.
will be done tomorrow.
Absolutely not.
You can't rush me to judgment, or you can't practice law from the bench and tell me when I can do something.
I think it's perfectly
Mr.
appropriate
Brooks,
to
I
request a
actually
little
can,
extra time
under
given the
all
number
the
of
rules of
charges.
procedure, it is my job to make sure there's effective and efficient administration of this trial. You are-
Then I should be allowed to, then if that's the case, then I should be allowed to tell the jury what they need to know, which is the truth, that they have the power. They have the power to nullify laws.
You are absolutely not allowed to tell the jury that. There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir. You have absolutely no right to raise that.
Did he really bring that up?
That is clear under the law.
I can raise what I want to raise.
No, you cannot.
And you can't, so you added in jury instructions at the last minute, then you should have never approved them from the get-go because I never approved them. I told you I didn't understand them at all whatsoever, and you still passed it.
Sir, if you understand jury nullification, you understand jury instructions. It's clear to me you've done your homework.
What you talking about? I don't care what you're talking about. I'm gonna let them
He
know
literally
that
said that.
They don't agree with, which is my right.
It is not your right to do that.
No, it's not.
It is not your right to raise jury nullification.
Show me lawful law then. Show me.
All right, I'm going to mute him once again. He's starting to raise his voice. He's starting to hit his hands on the table. It's very clear to this court that
is the
it's
fastest
going to
way
be a challenge
on
tomorrow
earth
during his closing arguments.
To lose your closing
He does not
arguments.
have an unfettered right to say whatever he wants or how he wants. If he is going to be adamant about defying the court's rules, which I will tell him in part what they are today, and I will work on that as we break and have a very clear advisement for him
Everyone
tomorrow
keeps
morning.
asking, I'll answer it.
He
on
may
break.
run the risk of being put in the
Oh,
other
he's still
courtroom
going.
because he'll forfeit by his conduct his right to be present here, and I will be able then to exercise the mute function. I have to balance, frankly, the fact that he's in custody, that it takes time for this jury to be excused. They have to walk an entire hallway behind me. I frankly don't want him to look worse than what he's looked, frankly, in front of this court when they haven't been in this courtroom. I need to preserve how he looks to this jury. And I will need a very clear pledge by him that he will follow the rulings that I make as it relates to the closing arguments. He cannot raise jury nullification. He cannot raise facts that are not part of the record. He cannot raise subject matter jurisdiction. He needs to argue the facts based upon his theory, based upon the evidence that's been presented. And those are the bounds. If he's going to, I can only imagine there may be some objections by the state. If there is an objection, I expect that he will stop and wait for this court to rule on the objection. I expect that if I sustain an objection, that he will honor it. And if he can't pledge to follow these very simple
I will explain what jury
rules of courtesy and
nullification is
decorum that are
when we have a
consistent
pause.
with the rules of procedure and the rules of evidence, then he will be in that other courtroom for his closing argument, so that I can exercise mute, frankly,
Rebecca, by
to
definition,
protect
is
how
it's
he
illegal.
looks to that jury. Because that is the balancing that I am tasked with tomorrow, is to ensure that this jury makes a determination based upon the evidence and the law. You do not have a right to talk about sympathy. That's very clear in the case law, whether it's evidence or arguments. The juries, if you read through the jury instructions, sir, you will see they are specifically told they will not be swayed by sympathy, by prejudice, or passion. They are not
We're
to
at the
be
guilt phase. We're
concerned
not
themselves
at the
with any
sentencing
penalties.
phase.
You can't argue penalties. You can't argue jury nullification. You can't argue legal issues that aren't relevant to the elements and the other law that's in these jury instructions. And those are the very clear rules that you will need to follow. And like any other time in this trial, if you don't do that, you will forfeit your right to argue your case to the jury, or forfeit your right to be present for
She's
in
literally
this
giving
courtroom
legal
and appear
advice
from the
right
other
now.
courtroom. And you are squarely put on notice of that here today, sir.
Contempt, but it's pointless here.
With that, I think I've addressed all of the issues the state has asked me to address. Oh, one other issue, verdict timing. I know we have some time on this. I realize that there are many victims who may still be watching the proceedings remotely. There may be news media, in fact, that may want to cover the verdicts.
Yeah, clearly.
And that
I'm
this jury
presuming
will
that's
take
sarcastic.
some time due to the sheer volume of counts in this case. When this court is advised that verdicts have been reached, I'm contemplating between 30 and 60 minutes before bringing everyone back into the courtroom for the verdicts to be read in open court. And if parties believe I need to wait longer, then let me know. But I think some of it will depend on is it late at night? Is it during the day? Are we dealing with any kind of traffic issues? I realize Mr. Brooks has family in Milwaukee area that may want to be here as well. Even if I consider kind of, the outlying areas of Waukesha, you could be as much as 30 minutes away. So that's my initial thought on that. Any statement from the state on that?
Not on that issue directly, sir. I'm sorry, Your Honor.
It's okay.
I apologize.
Any other issues?
Yes,
I'll
my
explain
other
some of
issue as
the
the verdicts was
intricacies,
seating, if you
but
intended to
that's
maintain
basically the idea.
designated benches for the reasons you just said.
I would intend to keep the seating as is.
Okay, with the
The
reserve.
entire side behind the stake for victims.
Okay, and the other side,
Public.
reserved for the first 5 minutes, or is that open seating over there? Or do you
My
wanna think
previous or my rule throughout has been 15 minutes.
I can't imagine anybody nullifying the
What
verdict.
I would say is any open seating will open the courtroom. It'll still be open the whole time because we're waiting, right? So it has to be. So any seat that's left open within 15 minutes, victims could also sit on the other side.
Okay.
If that's what you're asking me.
Yes.
All right. Mr. Brooks, any further topics by you?
Am I muted?
No, you're unmuted.
So, again, I don't understand nothing you just said, but
No, we know you don't understand anything.
I don't. How can you deprive me of my constitutional right? How can you trample on my constitutional right? How?
Sir, you can forfeit a number of constitutional rights by misconduct on your part.
Not if I reserve my rights. You can't let me reserve my rights and then take them from me.
Sir, I direct your attention to Chambers
Double
versus
secret
Mississippi,
I'm not
Rock
gonna hear
versus
none of that.
Arkansas, State
because-
versus Anthony, Illinois
did they
versus
reserve their
Allen,
Did they reserve their
God,
rights?
she's got an
the
amazing
Beneby
clerk.
decision. There's a host of case law, sir.
Did they reserve their rights?
All right, sir, you are simply mistaken on that. So I'm muting him once again. He's not giving me any other issues to address. We are in recess.
Oh, I'm sorry, I have a few
Go
other.
ahead.
I'm
You
sorry.
do. I'm
Yes.
sorry. Go ahead.
I just wanted the record to reflect that at about 2:04 p.m., your clerk had provided the final version of jury instructions to both the state and to the defense. I watched
the
on
DOJ.
video as
Good
Deputy
question.
Whitting left this courtroom, went over to the other courtroom, handed the final jury instructions to Mr. Brooks, and he immediately turned and dropped them to his left off the side of the table. I can't tell from the video if that's where the trash can is located or not, but I did see that immediate response after he was handed the final jury instructions. Another
Did that
thing,
include the verdicts or just?
We
jury
saw the
instructions?
bailiff take it out of the trash can.
Okay, it's just the jury instructions, but thank you, because I didn't see
You're
that.
just
Why is
going.
Some of the-
Yeah, you
I
too.
appreciate
You
that.
too, dummy. Uh-huh.
were all jurors or will all jurors then be told to report with an overnight bag?
That's part of the instructions that
Okay,
they were
and you're
given.
gonna make that available to us?
Yes,
Okay.
I'll get Lauren down here right away, and I'll make sure that before Mr. Brooks
Probably.
is
I could
taken
find it.
back to the cell.
Maybe not in
I see your arms
Wisconsin.
waving. I'll get you in a second. That he's provided with that as well,
All right.
and you as well.
Oh,
And
here
then
we
one
go.
final thing as to timing, and again, I don't mean to be disrespectful to Mr. Brooks or anyone involved in this matter, but should there be any guilty verdicts in this case, would you be intending to proceed to sentencing yet this week or at a future time?
You know, that's an interesting question because I don't know how many victims will want to speak. If we have time, I would certainly consider that. I mean, I have this entire
Forget it.
week
Let's
set
get done with the
aside
penalty
yet.
phase.
And I have Monday morning, but I have some other things Monday afternoon, and then I am not available the rest of next week. So it really just depends on the timing. I would need to know from both the parties whether they anticipate anyone speaking other than the parties themselves. Any family members?
Yes.
I don't think I need a PSI. This is a trial. This is not like a guilty plea. So, Mr. Brooks, I'll get you. I'm unmuting you. Go ahead.
Here we go.
Go ahead. You're unmuted.
Did you become an air traffic controller?
Since we're all making records to make me look bad, I think we should say for the record that one of the rights I have is to demand that the court place in the evidence any unrevealed contract, statute, laws, rules, or information being used against me under the Sixth Amendment. So how come that hasn't been placed in the evidence?
What law are you referring to, sir?
I'm referring to my rights under the Sixth Amendment.
And what
My
case law
constitutional
says you
right
have a
under the-
right to do exactly what you just said you have a right to do?
The Constitution, Amendment 6.
Denied.
Denied.
Sir, that is very general, your statement. It's vague. There's nothing
So we gonna go
specific
what?
you have
What
referenced.
You want
Also
paragraph
stupid.
2 or something like that? Is that
Stupid.
what you want?
No, that's not what I'm saying, sir. You're making
So,
general arguments
also-
that aren't based in fact
Yeah.
and are overgeneralizations of what the law requires as well.
I accept for value and return for value any documents in this matter.
I think the
Since,
fence needs to
it
come
might
out.
be another record of what I'm doing, since it's always a record of what I'm doing. And I also have the right to ask, is this common law or admiralty law? Because judging by the gold eagle on top of the flag, it's some explaining that needs to be done. That is a military symbol. So is this a common law court or admiralty law court?
Mr. Brooks, I'm frankly not going to address these nonsense legal theories of
There we
law.
go. I
I'm
told you it was
giving you,
coming.
You finally got to
They have been debunked. They are typical
Everyone-
sovereign tactics that have no place
calling
in our
bingo for
judicial
somebody
system.
now. I know some of
We
you
are
are
in
holding out
recess.
for
I'll see
everyone,
everyone
but-
tomorrow morning at 8:30. I'll just direct the bailiffs to wait until we have the verdict forms to give. And if it takes us longer than 30 minutes, we'll make sure they're delivered to him in his jail today. Thank you, everyone.
Thank you.
Oh Lord.
I'm not going anywhere until they go to the clock. Every time I cut out, he does something wackier. Oh, he's still going. He's still going, but he's muted.
He's yelling at somebody, but he's muted. What a freaking
We're
moron.
getting there, people. We are getting there. You hung with us. God bless you.
All right,
We love you all.
I want to answer, and we should give a reasonable answer to the folks on what jury nullification is. I think if we can do a little bit of education, I'll
Wait.
be happy for the day.
I'll let you do your jury nullification. I've just first need to give a content warning. You might learn something. I don't condone it, but here it is. And also, I'm going to let you do this because I've done during this. You're going to be impressed. I did a summation of today's events while it was going. So carry on. Go ahead. Jury nullification.
All right, so real quick, jury nullification. Basically, the fundamental concept is that a jury's verdict cannot be overruled by law. It's not appealable if they find you not guilty, period. So if they just hate the law and they feel like the law shouldn't be a thing, they can find you not guilty, and you're not guilty, and nobody can appeal it. That's the basic concept of jury nullification. The flip side is if they don't like
a whole
the
video
law,
on jury nullification, by the way.
huh?
I did a whole video on jury nullification.
All right, well, find a
But
way
back in
to
the
put
day,
that
it's
in the
awful.
chat.
I mean, You think my production value is bad now? You should go watch my video on jury nullification.
Now, the flip side is, if the law says that you should be not guilty and the jury finds you guilty anyway, you have an appeal, but they can still do that. So that is the basic idea of jury nullification. Ultimately, the fundamental concept of a jury system is you have 12, or for instance, in Florida, outside of death penalty cases, 6 people who can decide what laws apply to you and which ones do not. And that is very important for everyone to understand about how the jury system operates. Now, the reason that you're not allowed to talk about this in court is because you are asking lay people to basically overturn the law. And you're not allowed to do that. It is one of the quickest ways that you can get disbarred. If you ever bring up jury nullification as an attorney, you will be sanctioned, you will be disbarred, and you will never practice law again.
It's like touching the third rail.
Exactly. So that's why she is not going to let him talk about it, because it blows up a case in a way that the law does not anticipate and does not tolerate. That's basically where we're going. So did I do that about right?
That makes a lot of sense. But now I realize that I've got to make 2 trips.
Yes,
the thing I do for you people on YouTube. I now have to go to Tampa. Probably hang out at a beach at some point and drink with John. And it's clear to me that I now need to go to Vegas as well and hang out with Ben.
I mean, Clearwater is beautiful even during the winter. Still about 70-degree water.
Jury nullification's worked a bunch of times.
It has.
The classic example is somebody, I shouldn't say this, somebody who takes somebody out for doing something to a child, and they are charged with murder, and the jury says, nope.
The classic example, and I'll be careful as well, if somebody did something to my kid, and I responded in a certain way, part of my thought process is I don't think that there's a jury that would convict me.
Yep.
And that's basically the concept.
We want the fez for the whole closing argument. I'm going to be fezzed up. I might have to be fezzed up. I might have to wear a shirt. I might even button my shirt. It might get to that.
I'm wondering if I can order a fez and get it here overnight.
Yeah, you really, you know, this
the room might be coming out.
It was like party something, you know, online, whatever. The shipping was more than the fez. But it does have, thank you again, Griggsy. It does have a cool patch from Jeremy DeWitt. Apparently, supposedly pulled off. It's got little stitches on it too. Pulled off his uniform. Jeremy DeWitt actually.
Actually, you got it,
or so I'm told. Who knows? Who knows?
You got it, because Griggsy messaged me a couple days back, and he told me not to tell you about it.
It's awesome. It really is. It really is. Okay, so we're gonna do this. We'll be here tomorrow. We're getting closing arguments tomorrow, and it's really cool that we found out they're getting sequestered. The prosecutor gave us a bunch of stuff by asking questions, which was excellent. Jury's getting sequestered. We have enough. I was worried we were going to get COVIDed out of this deal. They're going to get sequestered, but I don't imagine they'll spend the night anywhere because, you know, I don't have the real trials off the top of my head, but it's happened many times.
I could find them, but it literally is like if you do
that would be a great, by the way, that would be a great, and everybody go over there and like and subscribe, but that would be a great video for your channel. That is something you would eat up.
I'll find a case.
Yeah, you know, find 2 or 3 classic examples of jury nullification and discuss them.
Those are a little rough with YouTube's terms of service, but you got to be
there's
be careful enough with that.
Okay, we will be here tomorrow morning at 8:30. I guessed at 8 today, sorry, but tomorrow will be 8:30. We'll have some nonsense, and then we're going to have the state's closing, which the prosecutor says she's going to keep short. It looks like 30, 45 minutes.
Which is not a long closing given the number.
It's not a long closing. And that's what I said. It was during the thing, but to me, that projects confidence. If you're going on and saying, I'm going to play 6 hours of video, it's like I want exhibits and stuff to do my work for me. That a prosecutor saying I can do it quickly is saying I'm confident. I've made my case. I know what's important. I've distilled it. I'm not wasting people's time. I will get it done.
Like I
Very
said,
impressive.
I think that she has practiced this half a dozen, if not a dozen times. She knows exactly where she's going. Everything is lined up and ready to go, and she's ready to pull the trigger. And meanwhile, he has no idea what he's doing on his side.
All right, so you ready for my learned summation of today?
Yes, please.
Yeah. Without getting into further detail, there were drugs involved that people were giving to me that ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack, and
I think that covers it right there.
I think that pretty much is a fantastic summation of what occurred today.
I really couldn't have said it better myself.
No, probably not.
All right. All right, John. Tomorrow morning, I will see you. Everybody, thanks for coming out. Now I have to go, like, all through this, you're like, oh, fun stuff happened in other courts. You got to see the memes. I'm like, I'm sure they're fantastic. But John and I are here slaving away. Very difficult. We don't enjoy any of this. We don't enjoy any part of this. It's difficult work, and we labor for you.
We're going to stay here, and we are going to keep bringing this absolute dumpster fire to you to the best of our ability. And Mike's going to be fun, and I'm going to try and actually have some sort of legal analysis, which
yes. And everybody gird yourselves. The prosecution is going to come in and talk about the real world consequences of 6 people dying, 60 people getting injured, and some real heavy stuff. For real. That portion will suck. But we're adults. We can handle it. We will sit through it. But that won't be fun. There will be other funny moments. Well, the funny moment will be him trying to defend himself.
Yeah, that's always the funny moment. It's the facts of the case, and I want people to keep remembering there are 6 people dead, and there are 60 people injured. This is not a funny case. He's funny because of his incompetence. But just
we get it.
Always remember that
we feel it here.
There are problems, and we're gonna try and have as much fun as we can with what we got from the circumstance.
That covers it right there in a very short phrase. All right. Thank you all. Thanks for coming out. I will see you all soon, namely tomorrow at 8:30 in the morning. All right. Thanks, John.
I'll see you in the morning, Mike.